My name is Shannon Bryant. I'm the Traffic Safety Resource Prosecutor for the state of Nevada. This is part of the TSRP training video series intended for Nevada law enforcement conducting DUI traffic stops. These short training videos are intended to refresh training for in-service officers who have already completed their Category 1 training. This brief training is actual physical control as an element of a DUI offense in Nevada, and it's designed to help law enforcement officers understand the law when it comes to actual physical control cases and be able to better assess when a DUI suspect who is not observed driving can still be charged with a DUI. With that, let's jump in. Nevada's DUI statute is found in NRS 484C110. And for this training, we're just focusing on the element of drive or be in actual physical control. Driving, of course, is not defined in our statutes or case law. So that means we're just going to have to use the plain common sense meaning of the word drive. Vehicle is moving, suspect is in the driver's seat, and, well, driving the vehicle. But when the suspect is not actually driving, and we start talking about actual physical control, it can get pretty confusing, unless, of course, you've seen this helpful video. But wait, you're thinking, isn't there a statute for actual physical control? Well, yes, technically there is a statute for APC. Technically, that is. NRS 484C.109 was added a few years back by our state legislature, and it describes one instance of when a person will not be in actual physical control. If you're confused, so am I. This statute lists a number of specific circumstances that, when all of them are present, the suspect is not in actual physical control. Remember, this is just one set of facts where you don't have actual physical control. Now this begs the question, how useful is NRS 484C.109 to law enforcement officers? For example, if a visitor from another planet came to Earth and asked me what a tree looks like, and in response I gave the visitor a detailed description of something that was not a tree, that visitor is going to come away from our conversation having no idea what a tree actually looks like. And this is just going to create confusion with our hypothetical interplanetary visitor, just as it does with law enforcement. And for law enforcement officers, that confusion leads to frustration. And that leads to poor decision making when faced with a potential actual physical control scenario. There is good news though. The Nevada Supreme Court opinion in Rogers v. State, a 1989 case, is still good, and it gives us the guidance that we need. Rogers remains the seminal case in Nevada for actual physical control, and it's valid in spite of NRS 484C.109. There is no bright line rule under Rogers. We're going to have to look at many different factors. Under Rogers, the investigating officer and the prosecutor should look at the specific circumstances of how the suspect was observed in relation to the vehicle. That would include the location of the suspect in relation to the vehicle. Where is the suspect? Inside the vehicle? Outside the vehicle? On which side of the vehicle? Is the engine running or not running? Is the suspect awake or asleep? If it's nighttime, are the vehicle's lights on or off? Where are the keys? In the ignition? On the floorboard? In the suspect's pocket? Is the suspect trying to move the vehicle? Where is the vehicle? Is it on public property or private property? And is the suspect in a position where he or she must have driven to that location while impaired? Arguably, this is the most important factor in Rogers. Since Rogers, more cases have interpreted Rogers and given us even more factors to consider, such as, was the engine warm or cold? Who is the registered owner of that vehicle? Many times, this is an often overlooked fact that can make the case when accompanied by an admission to driving. If it was a crash, were the seat belts extended and locked? Was there airbag deployment? If so, which ones? What about the driver's seat position? Was it reclined, upright, pushed back for a tall suspect, or up close for a shorter suspect? Are there marks from the seatbelt on the suspect? From which shoulder and in which direction? Is there blood inside the vehicle in locations that are consistent with injuries on the suspect? Are there open containers that are consistent with the observed impairment? One container, for example, is not consistent with observed substantial impairment. And don't forget that key question. Must the suspect have driven to that location while impaired? Let's look at a couple of examples, and you can be the judge. In the first example, the suspect is in the driver's seat. The vehicle is running. The vehicle is stopped on the side of the highway. There are no businesses or residences in close proximity. These were the basic facts of Rogers, and the court found that the suspect was in actual physical control of the vehicle for purposes of a DUI offense. The court found that the facts indicated that the suspect must have driven to that location while he was impaired. Let's look at another example. In this example, the suspect is in the driver's seat again. He's asleep. The vehicle is running and it's cold outside. The vehicle is parked in a parking spot in front of a bar that is open. According to the court in Bullock v. State, this was not actual physical control. The facts indicated that the suspect could reasonably have gotten impaired at the bar and climbed into the vehicle to sleep it off. It was not, unlike Rogers, a case where the suspect must have driven to that location while he was impaired. Documentation of observations in any DUI case is important, and in a case involving actual physical control, it becomes critical to proving that essential element. Do not simply rely on a suspect's admissions that he or she was driving. Those admissions will not be admissible in court later without some corroborating evidence in the form of observations that you noted in your report. Remember, proving these facts go to an essential element of the DUI offense, so the prosecutor will need to know as much as possible about your observations. Another important reminder here, Nevada's 2-hour time limit for DUI alcohol per se cases starts from the last moment the suspect was definitively driving or in actual physical control. That 2-hour time frame does not start with the time that you arrived on scene or the time that dispatch issued you the call. If you do not know the exact time of driving or actual physical control, and it's an alcohol DUI, you will need to obtain a series blood draw so that the toxicologist can properly perform a retrograde extrapolation analysis. A single blood draw will not normally be admissible if you do not know the exact time of driving or you're outside that 2-hour time frame. Please note that a series blood draw is not conducted for DUI drugs. Where drugs are suspected, there is no 2-hour time frame. However, the blood should be drawn as soon as possible after the driving or actual physical control. This concludes this training video. I'm Shannon Bryant, your Traffic Safety Resource Prosecutor for the state of Nevada. On behalf of the National Highway Traffic Safety Administration, Nevada's Office of Traffic Safety, and the Washoe County District Attorney's Office, thank you for all you do and for keeping Nevada's roadways safe.